Well, as I say, it's hard to believe that at the beginning of this month we haven't even had one session, and now we're only in the third or fourth week. And here we are finishing up. So hopefully you're all quietly confident in your knowledge of corporate and financial services laws. But this is just. If I bust it out, I'll do the track changes off the track and we'll go for it. That'd be good, wouldn't it? Just do it. Do it, everyone. I'm not going to fail anyone unless I do really bad things. Well, very good. Well, last night we overran and didn't quite finish looking at this fourth question dealing with Mr. Ned, who I ultimately determined was NED. And we talked, haven't we, about the need to keep assets between cells and as between cells and core identifiable. That was one of the issues. We talked about this issue with the investment manager. We talked about directors' duties in general, and the fact that in this question you are, in that first section, being asked just to give an overview of directors' duties and what they are. And the kind of headline points there were to go through SPL, which said that in the absence of Guernsey law, you can refer to the jurisprudence of the UK, and then more so to focus on Carlisle and the various duties set out by the court. From there then, things move on. You've got 15 marks dealing with two further sub-questions. 2 weeks later, Mr. Ned calls back. He's looked into the financial position of Cell Z and is concerned it may not be solvent. Advise Mr. Ned as to what steps he should be taking and any additional duties to those set out above. What was your thinking, if any? There? Mm-hmm. In what context? Why? Why is that important?
It's important because solvency is in this case, and I'm not 100% across how much of the cell obviously, with bigger creditors whose interests need to be given. Well, there's a question of what terminology of paramount importance is, I think, what we're discussing Carlisle. I think there's some debate about how much the interest needs to be considered.
Yeah, and what's the ultimate downside for Mr. Ned in all of this?
It's personal ability.
Why?
Or more training, or your directions, duties as a director.
Yeah. So those are all the issues you need to tease out there, I think. So he's looked into financial position of Cell Z and is concerned it may not be solvent. So he's on notice at that point. That's the signpost, the flag. He's on notice at that point that there are potential issues with the solvency of the cell, and that brings in considerations of trading and what not just he, but what the directors generally ought to be doing in terms of moving forward. Insofar as wrongful trading is concerned, it's a fairly straightforward formulation, as we saw in the last study weekend under section 435. But I think what's important to note is that within 435 itself, I can't remember which one it's on. There's various bits that you just need to remember to work through beyond the core offence here in section 1 of 434. The circumstances in which it applies, so going into insolvent liquidation, no prospect of avoiding going into insolvent liquidation, the person was a director of the company at the time, etc. 434 isn't 435. Yeah, here it is. 435. I was right. 435 sets out the equivalent provision, sorry, in the context of a cell. So that answers in an extent the point that has been said, is it all carries over in the same way. But what I didn't do here, because I was lazy, is set out all the detail. So 435, 1 through 8, set out the equivalent provision for wrongful trading, as is set out in 434 for companies generally. The effect is obviously the same. The core offence is the same. I highlighted 435 subsection 6 here because that just sets out the test for insolvency of a cell. So although it's still effectively a balance sheet type test, it's no different from that point of view of the test for wrongful trading in 434. It's again just being precise, I suppose, about the way in which you phrase, you formulate your paraphrasing, I guess, of the offence. Or if you just wrote it out as is, you're still going to get a mark for it, which is another exam technique point. To what extent you try to paraphrase these things? Well, I'm not sure there's any need. Assuming to section 435 subsection 6, the cell goes into insolvency if, and here it is. You can't really reinvent the wheel, can you, on that? But it's taking it to the next step, which is then your application. So it's one thing setting out the principle, there's your one mark, and giving the authority. The other mark would be, say, for taking that as an example into the context of this fact pattern, all you're told is he has looked into the financial position of Cell Z and is concerned that Cell Z may not be insolvent, sorry. So there's various ways in which that very limited information feeds into the overall test for wrongful trading. First off, he's not at an immediate risk because the company's not in insolvent liquidation. And the offence of trading only kicks in once here the cell enters insolvent liquidation. It isn't clear on the fact whether or not it is insolvent. You don't have that much information. But what you would go on to say is that if the cell did enter insolvent liquidation, this is evidence that at this point in time, prior to that happening, he had the relevant knowledge, or something bordering on that relevant knowledge. The facts here, though, aren't sufficient to say he will be liable, rather it's he may be, with the focus then on what steps he should be taking. And that is thinly veiled reference, I think, to the subsection that carves out relief for a director from wrongful trading in circumstances where they've taken steps to minimise losses to creditors. So 435 subsection 3. Yeah, so 435 subsection 3, a director may avoid liability if they've taken every step to minimise the losses to a creditor. And obviously it goes on, it's a bit more wordy, but that's something Ned needs to be aware of at this point in time. But you haven't got any practical information so as to be able to say how he achieves that. The other point that I queried there, bear in mind this is 8 marks, is whether or not it would be necessary to discuss the provisions that are set out in 448 through 453 that deal with the liquidation of cells generally and the protection of creditors. The reason why I'm hesitant is because, again, you're not in a position where the cell is necessarily insolvent, rather there's a suggestion that it is. What further steps can the directors be taking at this stage? And the provisions that go to the process of voluntary liquidation or compulsory liquidation don't really deal with the thought process that goes into that. They simply deal with, well, once the decision has been made, once a resolution has been passed, or what have you, this is what happens. And hence my hesitation, because again, under this second section, you're not quite there. Rather, those issues go into the third sub-question. 6 months later, it goes back to the financial position of Cell Z is improved, it's solvent. However, the board has decided in any event to get rid of Cell Z because they're fed up with shareholders complaining about its poor performance. How might this be affected? And here again, I was kind of a bit unsure for 7 marks. What is your advice going to be? The discussion I'd understood from the study guide was that it's common for Cell shares to be issued as redeemable shares, so that in those circumstances you could just redeem the shares. The PCC could redeem the shares in the Cell. You're avoiding processes of liquidation, etc. You redeem the shares in the Cell, and there's a neat end of life for that Cell. But again, I'm open to your thoughts in terms of what are the options there. The Cell is solvent. As far as I can tell, you can't just subsume the Cell as you can in an ICC.
If you could redeem them,
Yeah, if.
the same as me now. Yeah, that would be the latest way.
What do you do with the assets, though?
Well, it's not the assets.
It's kind of like a quasi-process of liquidation in a way.
That's the directors can really do about the
Yeah,
Yeah.
just do it in an orderly fashion and then.
Isn't it just asking us to talk about the expulsion of the Cell? Which is just discussing more about.
Is that a thing?
Yeah, it's like, yeah, expel the Cell. It's like somebody not, it's like they've lifted like words from biology.
Yeah.
That's quite right. Is it all the companies know about that?
No, I don't even know it. So redemption out and then
I haven't done it in Guernsey, but in another jurisdiction, we just redeemed everybody out, paid them their money, and then the directors just resolved to dissolve the Cell. But there was nothing particularly in the law about it. We just
No,
went with it.
it was not here. I thought is again, I was thinking, trying to kind of preempt what the issues might be. You could, and I don't think this would be attractive, but if you couldn't redeem, you could convert it to a non-cellular company and then put the non-cellular company into voluntary liquidation. But that would be such a long-winded process. But ultimately, sale of assets and distribution of the proceeds. I was struggling to see any other way of giving effect to that, because it's a solvent Cell. How might this be affected, and what other considerations should Mr. Ned take into account? I wonder if it's a bit of a red herring, because what are the other considerations he would need to take into account? Or is that coming just back to general duty? They want to get rid of it because their board of shareholders complaining about its poor performance. So is that just going to, is that going to exercising powers for their proper purpose, acting in the best interest of the company, maybe? it's a bit too vague for my liking.
Does this require shareholder approval to get rid of the cell, anything like that?
I don't think we're all surprised. Anything in that space, yeah.
Yeah.
And you could ask shareholders, but
Yeah. I think that must be it. If it's a straightforward redemption, and you're then looking to the exercise of power by the directors, then in exercising that power, they are obviously doing it subject to the duties that they owe. Those duties include acting in the best interest of the company and exercising their powers for a proper purpose. I think that's probably the extent of it. And you kind of bear in mind there's 7 marks, that's probably, you've got 4 marks or so for talking about that process of, so it's not going into the detail because you don't have the information, but you're assuming the shares are redeemable. And then chatting through the issues on directors' duties, but it's a bit of a tricky one. Maybe I'm reading too much into the amount of marks that have been given.
But just in the same question 4 in the first part, we've already discussed all the duties. So
Mhm.
I think it's probably unlikely to be asked to set all that again.
I don't think so. Certainly, I wouldn't mark in that way. I know some examiners would, and then require you to basically repeat what you've already said in order to get the marks. But I don't think that would be necessary or intended here, and certainly I wouldn't mark in that way. Providing obviously you refer back to your earlier discussion. Laurent, have you found?
It's not expulsion. That's a
ejection.
yeah, that's for I think it's for like something trading fraudulent. I think it's more sort of political winding up. So
Good to know.
that's what
Maybe there you go, an omission in the law.
it's a ordinance about it. Don't talk about it.
Well, that's that. Yeah, so I couldn't obviously identify that there would be any more to it. So reflecting on that as kind of 25 marks, how many would you have got?
13.
Yeah.
Optimistic. Is there anything in all of that though that what we discussed?
I think
Yesterday
it's
as
a
well.
sort of question what we would expect from them. Like phrases issues. You know what you're being asked more or less to deal with. It's obvious what it's about. I think.
Is there anything you can sort of go with your sprinkle over? Yeah, that's pretty basic stuff.
There's nothing too clever in all of this,
No.
is there? Unless, or too technical, unless, the example here, you can demonstrate from your technical knowledge some way of getting rid of cell Z other than redeeming its shares if they're redeemable.
And that to be issued as redeemable.
Exactly. I mean, I'm just taking that as an example of these types of questions generally. Some practitioners may simply have the technical knowledge from practice of having dealt with this type of issue that they might be able to set out how you would structure it. But my point was going to be, you then come on to issues in practice that are so specific, so technical that even even a Guernsey practitioner, if a litigator wrote this paper, they may not actually know that there was this convoluted process by which you could achieve this aim. And when they see that set out in somebody's answer by a transactional lawyer, they may say, oh, right, okay. And they'll then check back and tick it off and fine, have some marks for it. But it brings me back to what I've said before, which is you're supposed to be on a level playing field. So the answer that Jasmine gives for this, I'll put them down, as a litigator, the answer that Jasmine gives to this, in theory, should be no different in terms of the marks which are achievable than a transactional lawyer should give. That's in theory, it should be a level playing field. So I'll tend to err on the side that there's no kind of magic wand, there's no hidden technique. As you said, to sprinkle some gold in it, I just don't think that's the intention. It's just to try and make it as broad and as accessible as possible. But the problem with that is you then lose a little in translation as to what precisely the answer or the outcome is going to be. Yeah. Okay, well, bear that in mind. And then if we flick over, you'll see I've got a June 27 paper that I wrote for the JLC. And you will discover that the setup is similar for the JLC, in that the students have to answer 4 questions. They're worth 25 marks each. However, they do have a choice. There are 6 questions. And so they get a choice, whereas you're lumped or you're landed, whatever, you're stuck with the 4 that you are given. And if you don't like them, well, tough, because that's what you've got. Now, you've got the first question, the third, and the. Oh, I'm missing one. Am I missing one? Oh no, there's the 4th, hidden away. So you've got 1, 3, and 6, which are problem type questions. The 4th is an essay, it's a critical discussion. And then 2 and 5, because clearly it's needed in Jersey, are just straightforward knowledge-based questions. Tell me about these very basic procedural points. And as I said, I've been lifting those out year on year, so that this year there won't be any, I think. But you see what I mean, looking at 5, for example, schemes of arrangement.
Look at that law.
Well, that's how they've been drafted for, those questions have been drafted for, I don't even know however long they've had standardized papers on the JLC. And some of the papers were 6 of those. When I started, there were 6 of those. So what is a scheme of arrangement? What's the first step? What's the second step? What's the third step? Maybe you should practice in Jersey. Like I said, moving away from that anyway. So what I think is more useful to look at is 1, 3, and 5, 1, 3, and 6, because those are problem questions that, as I said, I've written, which will give you a better feel for my style. Obviously, they're set up as Jersey law questions, but that doesn't matter because there's nothing specific, I don't think, in any of them that go to issues of Jersey law per se. They just present general issues of company law, and as such should be capable of being answered, whether you're advising under Guernsey law or English law or whatever. So have a quick read through that first one, Helier Furniture Limited.
Give us a copy. Had a slight children disaster.
I gave you one, yeah. Oh, right, okay.
Yeah, I shall.
Are you sure?
Yes.
Just as a kind of starting point, then it's that's more representative then of how I prefer to draft these problem questions. It's, if you compare it back to the question we we're just looking at with Mr. Ned, it's obviously far more fact specific. It's more of a story in a way. And you're being given full rein to simply advise Joan 25 marks. And obviously the onus is on you to determine how best to break those available marks down, and what the issues are that need to be covered off. You've already started doing it, so I'll give you 5 minutes to get some thoughts together before we discuss it. But although it's more wordy, although it's more fact specific, I tend to think that gives students a better steer as to what the issues are that they need to draw out and discuss, as opposed to, back to the question of Mr. Ned, those more broad, general questions that leave a lot of facts unknown, and thus make it more difficult to simply determine the scope of the advice that needs to be given. I like to think these types of questions, it's easier to determine the scope of the advice, notwithstanding the fact that there may be some uncertainty in the legal principles themselves, or the way in which the court would apply those principles. That's fine though, because that's, as we discussed yesterday, just a case of leaving it open-ended. There are 2 arguments. If that's the case, you set them out, and that's your advice. The determination of those issues is simply left to the discretion of the court. And I'm more than comfortable with that advice being given, as opposed to trying to find some concluded, determinative answer, because more often than not in practice, it simply doesn't exist. Might do for transactional lawyers, because you've got you might have a straightforward way of structuring something, but certainly, you know, as a litigator, I like to have that uncertainty, because otherwise I wouldn't have a job if it was all too black and white. So that's that. What was I going to say? Who are you advising? Who you are asked to advise? A liquidator. Are a liquidator's objectives likely to be different to those of a director or a shareholder? Yeah. So again, remember to ensure you're clear as to who you're advising and what their likely objectives will be, because that will impact not necessarily on the advice that you give, but certainly the way in which you frame it. And there I'm thinking with regards, for example, a director who may have acted in breach of duty. We know that that director could potentially apply to the court for relief under Section 522 from liability. If you're advising the director, then that's something that you might be advising on quite strongly and trying to build an argument pursuant to which an application would succeed. When you're discussing the same point for the liquidator, the framing is important, because you're advising the liquidator that it's a risk, there's the potential the errant director could apply for relief, and you're still giving the same basic advice, it's just how you frame it. It's not a discussion for the sake of a discussion and for the sake of ticking off marks. It's giving an advice, and there are reasons why you give us that advice. For the director, the Section 522 application is a positive thing. That's something they want to try and succeed in making to avoid relief of, to avoid liability for whatever their breach of duty is. The liquidator is potentially a negative thing, and it's a risk they need to be aware of. But you're still giving advice on the likely prospects of that succeeding. But that's kind of getting ahead. I just wanted to flag up just a basic point of exam technique. Read through the whole of the question and determine exactly who you're advising. it was important on the Mr. Ned question because there was scope in, I think, the first section to potentially talk about issues of solvency, insolvency, etc. within your general discussion. But in fact, if you had read on, you'd then discover that those issues are drawn out specifically in the next sub-question. And I do still see it on the JLC where the students haven't read on to see what they're going to be asked next. And they give that whole advice, and then they're having to repeat it in the second, in response to the second part of the question. But sorry, I interrupted because you were starting to make notes. So just for 5 minutes, have a quick run through and put some thoughts down, and then we'll discuss how we would advise Joan, and more importantly, how I would mark you for advising Joan. What's the approach to say then? How would you sit down in the exam? You've got 45 minutes. What would your formula be? There's no right or wrong answer, Mike. Just in terms of structuring an answer to that, you've got 25 marks.
Because for what it's teaching, the company and the directors.
Mm-hmm.
I think I would start with saying like the company's going to liquidation. This is its history.
Mm-hmm.
One of the largest transactions it did was a purchase of a £1,000 store.
Yeah.
But that hasn't worked, that strategy hasn't worked. It was a risky strategy, but the directors consider it. And then we really start talking about each of the directors.
Mm-hmm.
Archie, who's a qualified accountant,
Yeah.
for a high standard of care.
Mm-hmm. Yeah, indeed.
The Bella, who does nothing,
Mm-hmm.
although she does present furniture, low price furniture, programs, so is indirectly profiting from that side of things, but not taking any care of the any of the director's duties to the company.
Is that in itself a breach of duty?
To do that, well, without there's some thoughtful planning care to the company.
It also depends what's in the rights possible in terms of the payments that maintain.
Mm-hmm.
Maybe she's got an alternate director appointed. I mean, I don't know, I'm speculating, it's all in the fact.
Exactly. So, based purely, the only advice you can give is that which you can give on the fact.
Yeah, that's all I'm doing. Right, so go this question, talk about the articles, just say.
You know, when you about you look at it, you
Well, I think you might check the article, you might just say check the articles for like, forms.
Yeah.
With the casting, but beyond that, I don't think there's quite say that discussion. You know.
I'm just wondering, is there a simpler answer?
With Bella, might be more. He hasn't breached. He's not coming out.
Mm-hmm.
She's not actually in the best interest of the company. She's not dedicating any time.
yeah.
What if she says, well, I had a full-time job, everybody knew that. I didn't know what Archie and Charles were up to.
Should have.
The way I,
Like, so it's a duty to have a high-level overview of what the company's doing.
Okay. Is that in Carlisle?
No.
Okay.
Well, if we're looking from a liquidator perspective, and making applications for whatever, opening statements, whatever it is, whether the directors knew or ought to have known, so maybe Bella, even though she didn't maybe actually know, she should have known because she was a director of this company.
Authority.
I'm sure it's lurking there somewhere. Yes, in Quebec, isn't it? I'm sure it's on the newspaper.
Yeah, no, indeed there is. So Manhurst Leasing, the court says that basically ignorance is no defence. And you're all right in terms of what you're saying. Carlisle doesn't quite go so far as to say there's a duty to take an active role or anything along those lines. It's not judged from that point of view because every situation is different, and there may legitimately be circumstances where it's agreed that somebody doesn't take a day-to-day forward-facing role in governance. Nevertheless, they're still subject to the same duties, the same standards.
What was that? Landhouse leasing.
Landhurst,
Landhouse.
yeah, leasing. The court says, well, it's no defence to allege you just didn't know. So it's not quite the same as saying there's a positive requirement to be informed, saying it's not a defence to say you didn't know. A nuance in the course applications of that. That's jumping slightly ahead. I'll just touch on it while we mentioned Bella.
Your fault. Are you still on a roll?
He
No.
was on a roll. What's the risk of? So Ollie said, look, you've got 4 different entities. We've got the company and we've got 3 directors. What's the risk here, just from a technique point of view, if you're dealing with each director separately into?
The risk is that you feel you need to apportion your time each of them equally, and the bulk of the marks to be happy. So I think there's probably, I mean, very roughly 15 points for A, 5 for B, 5 for C, or maybe, yeah, I think that's crude, but probably accurate. So if you, my approach is pretty much the same as all of those, but I would probably just be a little bit more mechanical. And just say you've got 3 people you can go after to contribute back to the company, which is what you want to do to liquidate.
Yeah.
A, B, and C. Let's start with A. That's 4, 3, 4, or 5. Potentially, yes, go through that.
Yeah.
And then you can,
I'll tell you from a technique point of view, what's the best thing to do? This thing, this is sustainable.
or maybe you do, sorry, you flip it, right? You do the law, and then you see whether it applies to each one. It doesn't apply to it.
Because you've got Carlisle, haven't you? And you've got these various duties. I'll come back to the other points I mentioned in a moment. And within that, you've got 4 different kind of duties that you're going to end up potentially talking about, though only discuss those which are relevant on the fact. And that's a big chunk of text. That's going to be half a page worth of discussion. We want to say within that directors' duties are owed to the company as a whole. You've got Percival and Wright, which the Guernsey Court affirmed in Carlisle. For each of the duties, you've got kind of explanatory jurisprudence that goes on to help understand the interpretation of those duties and what they mean. And then you've got the application of each of those to the relevant directors. The alternative approach, which, and again, I see this every year on undergraduate and on the JLC, is that people identify our 3 actors, okay, and they start talking about Archie, and they start talking about Percival and Wright, and then Carlisle, okay, and then various duties. And they do all of that for Archie, and then they come to, I don't know, whatever B's name was. And often, be surprised how often it happens. They don't talk about Percival and Wright, but they start talking about Carlisle again. And the duties. And I don't know why, but normally then for C, they just talk about the application. That's generally what it tends to do. Point being, however it comes about, they may sit Carlisle down here again. Point being that this approach tends to lead to duplication. And it's just not necessary. I'm just thinking purely from the point of view of saving time. I said maybe in the last video, you've got 45 minutes for each question, in effect. And you need to make sure that for each question you are giving equal amount of time to maximize the likelihood that for each question you'll get your 13 marks.
or ideally more tasks. You don't want to be in a position where you're simply trying to get 25 marks out of the first question at the risk of spending an hour and a half doing it, and then in the afternoon, 2 minutes or so to do the fourth question, meaning there's no way you could get 50% of the marks. Your overall average is then skewed because the amount of additional marks you're getting in the first question, the extra time you've spent, just isn't as valuable as the basic law and discussion that you need to include in that fourth question to get up to 50%. That 50% will come a lot more quickly than the 75%, the 80%, the 90%, you know, those higher marks, because they are having to be incredibly precise to get to the top end of the marks.
Looking at the actual question being asked to answer, what action might we would take? I'm not sure I would have started with a detailed discussion.
No, I wouldn't leave that.
Okay.
I wouldn't leave that.
Right.
I would simply say that
Sorry.
just while we were on the topic.
Oh, okay,
No, sorry.
yeah, I was kind of, yeah.
No, just occurred to me that it was just a good example
Yeah.
of why we were discussing it.
Yeah.
You've got three different people, but each are discussing the same body of life.
Yeah, that makes sense.
And you know, in a class of 4, you may be sitting there, that's how I would present it anyway. But in a larger class, I can guarantee that there would be students who would have done this slightly more chaotic approach, which may have the same answer. But I'm simply saying, purely from the efficiency point of view, there's an easier way of doing it. Set out the law, and then how that applies to the relevant parties. Now, I can't remember who said that, I think Lauren said, look, for A, Archie, you've got the bulk of the discussion in reality, insofar as potential liabilities are concerned, probably more falls on him than on Bella or Charles. And so that's fine. It doesn't really make any difference insofar as this work through is concerned. But that was just that point in isolation. You've got the law, set out the general principles, set out the authorities, and then work to apply them. Now, the only other thing I would say is, again, taking director's duties is a good example of this. You've got Carlisle's general framework of duties. You've then got what? I think 4 identifiable duties in themselves. An alternative approach, again, would be to make your advice a little more methodical and deal with the law in respect of that first duty and any explanatory law that you need to include from the English jurisprudence, and then apply that as between A, B, and C. In respect of that duty, based on the fact, is there likely to be any breach? You can then move on to the same for the remaining duties. The reason why that might be an attractive approach to take is because if you run out of time, then that first duty, say, or the second duty, however far you get, you've set out the legal principles, you've applied it, you've given your answer on that point. And if you remember, if you think back, again, I know I mentioned this previously, 25 marks. For these questions, those 25 marks in reality are broken up slightly differently to what you said earlier. Those 25 marks in reality look more like 15 marks for an accurate knowledge and understanding of the law, and 10 marks, say, for your advice, your analysis. And that 10 marks is almost entirely subjective, because one student may give one answer, another may give a different answer, providing they're properly reasoned on the law. That's no different to having 2 different advocates in the courtroom. So bear that in mind as well, that
those 25 marks. I know this is, you're spot on, as in that's the approach we took with the Guernsey paper. But here, those 25 marks, I'm not splitting 10 for Helia and 5 for Charles. I'm not doing that. Okay. If you see that now, 25 marks, problem question, you need to be thinking, right, I'm going to get about 15 marks for setting out the law here, describing the legal principles. Maybe it's not quite 15, maybe it's 12 and a half. I'll have something. There will be a mark scheme. The balance then is simply for my critical discussion, my analysis, my application, the advice that I give in practice day to day. It follows then that if you're simply looking for 50%, and that's where you've decided to ground yourself for the purposes of this exam, if you were to just write about the law, and you guys won't, I know, but believe me, people do. If you're just setting out what the court said in Carlisle, say, then you're going to struggle to hit 50%. And it still happens, more so on undergraduate courses, but I had a couple in the last round of the JLC where I don't know what it was, but that was all they couple of students, that's all they did was just set out the law. Well, that's the complete opposite, polar opposite of what normally happens on this course, on these courses, which is that they just set out the answer. Which is what I'm, but again, it's something to think about, but in a way, I hope it's actually a bit more accessible, a little simpler than some of the previous questions we've looked at, where actually we don't know entirely what the scope of the advice is. And that's the difficulty. Here, the scope of the advice should be clearer. You're then working on making sure you've got a reasonable split between your explanation of the law, the authorities, the reasoning behind your advice. Which then makes up the range of the answer. And there are different ways of approaching it. And do you know what? Someone might take what's set out on the second half of that board, and it may be very well written and it may be concise. I'm simply saying, in my experience, there's simpler, quicker, easier way of setting out these discussions, headline principles. And then with something like director's duty, that headline principle breaks down into the individual duties themselves. Obviously, for other areas of the law, you don't have those kind of secondary tangents to work on. You just have a main principle. Here you've got a main principle, you've got tangents to work on. And I would say probably your best practice, again, thinking about the time limitations you're subject to, will be to look through each of those tangents, here the duties, in turn, apply them on the facts, has there been a breach, and move on. But bear in mind, in this case, I don't think you'd necessarily be alleging a breach of, for example, the duty to exercise independent judgment. You might think otherwise, but my reading was there wasn't really anything that went to that on the facts. And if that's the case, you mention that in your general overview of what Carlisle's about, but there's no need to then go on and
include that, the discussion of that duty any further, because you're not advising the liquidator that it's been breached. You stick with one, I don't know, 3, 4, whatever, and just focus on the core duties that the liquidator needs to be concerned with. So those are my kind of thoughts on that. But again, it's jumping ahead. It's entirely non-structured. But what would be then? You said you wouldn't take that as a starting point, and I completely agree with you. It was just a useful point to discuss while we were on it. What would you take as a starting point here? If we were putting together some kind of superstructure for our advice?
Well, I'd start by setting out the law.
What law?
434.
Which deals with what for those of us who
Fraudulent trading. I did have to look it up.
Did you look at fraudulent trading?
Sorry, we find wrongful trading. Sorry. Yeah. Yeah, wrongful trading. this.
Mhm.
I guess you get maybe up to 3 or 4 points for just setting out what it says.
I think also what are the liquidators' duties would cover. And then move into that.
The only thing I'd say on that is advise Joan what action might be taken in respect to the foregoing. So you're being directed, you're being led to practically what can she do.
Right.
The way I had it kind of as a high level overview, the way I was going to do it, and I don't have anything to add to this at this stage. So my advising, what are her interests?
Yeah.
What actions are potentially available?
Mhm.
Apply that to the facts, set out the law,
Mhm.
go through each of the duties, and then some form of board advice conclusion.
Mhm.
But that was after, 10 minutes of having looked at this, thinking, oh my god, there's a lot of information.
Mhm.
How do you distill that? And I think that's where I'm going to lose silence. Rein in the chaos.
Okay, well, I'll tell you now. As I said, this is my preferred method of assessment. This kind of fact-specific question. As I said, it narrows the scope for the kind of advice that you need to give. But yeah, it's time-consuming. Now, I will tell you, I think because it's fair, I haven't got away with 4 full questions of that level of detail. I've been scaled back a little, which will mean that you can expect a couple of the questions to be a little more broadly aligned with the style of questions we've been looking at earlier today and yesterday, which do give you a broader remit to very quickly get to what the issues are. But within that, I have still tried to keep in some more practical type analysis, taking Ned, for example, a broad framing of a question, which, just taking what you said then as, it taking time to get into what the issues are. It's a easier, simpler question to quickly read through, address and understand the issues, and then give some thought to what you're going to set out. I've not gone away from that completely. So
It's just more to kind of pick the brains as to how you would see that structured. Maybe we can
yeah,
be able to recognise it ourselves.
Yeah.
I think that's what I'm struggling most with, is just to be able to frame it sensibly.
yeah. Well, no, I think that kind of headline structure you've set out, it makes sense. The problem you've got, the big unknown, is I think it's your third bullet, which is basically what are the causes of action. So Lauren's taken us through wrongful trading, which is obviously a potential issue on the facts. You've seen that the signpost here is that the company is running at a substantial loss for many months. Any suggestion that a company is loss-making on the facts of a question like this is going to be a signpost towards potential wrongful trading. Does it mean that categorically the directors will be liable of wrongful trading? No. So what are the kind of headline issues or points, I don't know, that we need to review? I don't want to go through all of the law relating to wrongful trading, but it isn't as simple as simply saying, here's subsection 1 of the 434.
I think we're doing your formula, which is you kind of set out what I think you have to. I don't know if I would use you quoted from the law, right? Pretty much.
For the purpose of the
I
slides,
think in our exam we would write that out, but probably short. And then we'd say, yes, the company.
No reasonable prospect.
Well, there was a reason.
There was a reason.
So we kind of like talk about.
Yeah.
But I think we just have to say, yeah, like this applies to directors, so this is where you want to hang your hat. Probably, I said fraudulent trading, I was wrong too, but you say, Joan or whatever her name is, won't wish to look at fraudulent trading because it's a hard test for people that are.
Is there any suggestion of fraudulent trading on the facts?
No.
In that case, chuck it out.
I mean, for what it's worth, I don't think actually that any of, I think they could probably, actually escape. I think each of the directors probably could escape fraudulent trading potentially.
Wrongful trading.
Sorry. Yeah,
You don't have a baby yet, do you? I had the party goers outside the cancer research. I'm not sure why that's the place to hang out, but apparently so. Yeah. So subsection 1. What you're not going to don't just copy that. Pursuant to section 434, subsection 1, Joe may apply to the court for an order that any or all of the directors make such contribution to the assets of the company in liquidation as the court sees fit, as a sentence on that. Okay, that is not only addressing what the law says, what the principle is, and giving the authority, but in its way, and I know it's very superficial, but in its way is your kind of practical advice. This is something she can do. Joan can, pursuant to section 434, subsection 1, apply to the court for an order that any or all of the directors make such contribution to the company's assets as the court thinks proper. An application may be successful under 434, subsection 2 if the company has gone into insolvent liquidation. B, C. But for each of those, there's analysis, there's application, there's advice you need to give. Are these conditions satisfied? So an application under section 434, subsection 1 may be successful if, under 434, subsection 2, the company has gone into insolvent liquidation, which, you say, on the facts, it has. Right, what's the next step? 2, at some time, so you can say, well, look, Archie knew that the company was in financial difficulties. The uncertainty is whether or not he ought to have concluded there was no reasonable prospect to the company avoiding going into insolvent liquidation. I just said to Laura, look, does that automatically mean an offence of wrongful trading, that a company is trading at a loss? No, it doesn't. It may have the cash reserves to maintain that continuation of trading. So there's no automatic liability. You've got to prove that he knew or ought to have concluded there was no reasonable prospect of the company avoiding going into insolvent liquidation. And it's that point which you then need to then go on and discuss in a bit more detail. What standard is he going to be held to in making that determination? Do you remember?
He's a qualified accountant.
Objective and subjective.
Yeah. So there's a built-in subjective and objective test under subsection 4. And as I said, having regard to the fact that he's an accountant, he will be held to the very highest standard when his decision making is being determined, the extent of his knowledge is being determined for the purposes of any application under 434. So that would be a relevant discussion. Subsection 4 and the test which is applied. Subsections 5 through 7 you wouldn't need to refer to on the facts.
Perhaps 5.
Okay, yeah. I was thinking about Archie, but yeah, insofar as Bella's concerned. But is there any kind of what do we know about, I don't know, the extent of any agreement between them?
Yeah, he himself already held it. It might just survive. It was clear that one of the other directors who actually attended this meeting to decide disapproved of the plans. I'm not sure that we're supposed to be sucked into the fact that it's a related party. I'm
No.
sure.
Not at this, not in the context of wrongful trading. No.
So there's additional reasons on the fact to conclude that maybe.
Well, the only other relevant point to draw out, I think, is under subsection 3, which is the avoidance of liability in circumstances where the director took all steps, which are not defined, of course, because they're fact specific, but took all steps to minimize losses to the company's creditors. Again, you don't know, this isn't one for you to call, but would the court consider that his further investment to try and boost profits would satisfy that? Yeah. Or was it too risky on the converse of that? Now, chatting it through, it all seems quite, overwhelming. How do you draw that together? But the fact is, you're simply looking at 434, which one by one goes through methodically the subsections. And yeah, it runs to 8, I think. But actually, if you read, is it 7 or 8? If you read through the latter ones, they're just not really relevant on the fact. So it would take you any further. Core discussion is liquidator can apply. Subsection 1 for a contribution from all or any directors. Subsection 2, well, in what circumstances will an application succeed? Must be insolvent in insolvent liquidation. Yeah, tick. Must have been a director, jumping onto the third requirement. Yeah, tick. And then the discursive point is, well, they knew or ought to have known that there was no reasonable prospect of the company avoiding going into liquidation. That's the point for discussion. You're then jumping forward slightly onto subsection 4 to say, well, in challenging and testing whether they knew or ought to have concluded no reasonable prospect of avoiding insolvent liquidation, you're then looking to the test under subsection 4, subjective and objective. Archie is going to be held to a higher standard as an accountant than the other two, who don't appear to have any particular special knowledge that would raise the standard for them. And you're not, I don't think, concluding, I don't think you can on the facts whether or not liability is likely to be imposed. In any event, you then go back a step to subsection 3 to say any or all of the directors may still avoid liability if they can demonstrate that they took all steps to minimize losses to creditors. In fact, you could probably be a bit more bullish about, I think. On the facts, there's no indication that Bella or Charles took any steps to reduce losses to creditors. As to Archie, it's a double-edged sword because it's unclear the extent of the risk to which he exposed creditors by entering into this new venture. For that discussion of wrongful trading, there's probably, and I'm going to regret saying this because my maths won't add up at the end of the day, but there was probably 4 or 5 marks in the mark scheme for that discussion. Now that's a very specific, insular discussion, isn't it? Wrongful trading. It's its own offence. It gives rise to its own liabilities. What's the other aspect of the discussion? Where else do you need to go with this insofar as asking Joan is concerned? We've talked generally about the law going to breach of duty, but not in any detail. What's that actually framed within for Joan's purposes? How would she, how would any of that actually be actionable by her? Well, what is her cause of action? There are any very specific.
Yeah, it's a bit,
There's any specific causes of action available to a liquidator. One of them is wrongful trading, one of them is fraudulent trading, misfeasance. So claims for breach of duty brought by a liquidator fit within misfeasance. Okay, and you said it earlier, Jasmine. That's why I left it as an open-ended. Yeah. Yeah, 42. So again, similar starting point under, pursuant to section 42, subsection 1, Joan could apply to the court for an order that any or all of the directors again be held liable for misfeasance in circumstances where there's no suggestion that A applies on the fact, so chuck it out, don't worry about it. B has become personally liable for any of the company's debts or liabilities. Well, if there was a successful application under 434, then B would be satisfied. But at present, you're simply advising prior to any action being taken. So strictly speaking, B doesn't apply. That would be a matter of how you pleaded it. And I don't think it's frankly hugely important, because C does arguably apply if you can demonstrate that there is some breach of duty by the directors. And so hence why I think it's probably important to set out, to frame your discussion of directors' duties within the context of 422, within the context of an application by Joan, the liquidator, to hold any or all of the directors liable for misfeasance on the basis that they are guilty of some breach of duty. These are the reasons why you say they are guilty of some breach of duty. Doesn't sound very smooth. It sounds a bit scratchy. So I think I personally would kind of set out the points about misfeasance first, and then go on to how are you going to prove misfeasance, which is your discussion of directors' duties. You could do it the other way around and just talk about directors' duties, but you need some kind of lead in to why it's relevant, and this is why it's relevant. If Joan can establish some breach of duty, and under 422, subsection 1, subsection C, she may have grounds on which to apply to the court to hold any or all of the directors liable for misfeasance.
So that would be all pretty.
Potentially, yeah. Again, my only hesitation is, you could look at wrongful trading first, you could look at it later.
Yeah.
It exists within its own little block, really, so it probably doesn't matter. This is the headline discussion, though, frankly. This is misfeasance. All of this is behaviour, conduct, which constitutes misfeasance. Historically, misfeasance was just the common law term used for any kind of inappropriate behaviour. Now distilled into
I think this is slightly confusing.
misfeasance, as I said, just as a common law term, was any wrongdoing by directors. And I don't think there's any intent that there's any need to read into that. because if you looked to Carlisle, you'd be taking a very, very academic view, I think, to try and distill fiduciary duties from non-fiduciary duties, because on my reading of it, frankly, although they talked about fiduciary duties, they didn't specifically single any of the 4 core duties that they set out as being non-fiduciary duties. It's all talked about in the same. I think it becomes too academic when you're simply trying to, when you're trying to understand the reason why it's phrased in the way it is. And bear in mind that at that point in time, the Guernsey law didn't have the statement of directors' duties that you now have in Carlisle. So at the time it was drafted, I think the use of misfeasance as a term was just to leave the door open to cover all manner of wrongs. Now, I may be wrong, perhaps there was some very specific reason why fiduciary duties were carved out, but I just don't think it's likely. Because at that point in time, you didn't have the law to say, well, what are the fiduciary duties of Guernsey? 422 subsection 2 just describes the persons to whom the provision applies, so it covers directors, former directors, etc. So that's not hugely, it's not hugely interesting. It's not a discussion I'm really advanced, I don't think. Subsection 3 though is, but not at this stage. Subsection 3 sets out what the remedies are. So on a successful application, court may order the relevant person to repay, restore, or account for money or property, contribute to company's assets, etc. That's your remedy. And I think Rachel, you said, didn't you, in your kind of overview, your 4th or 5th bullet was dealing with, well, what's the outcome? What next? What's the purpose of all of this? And that's your discussion of remedies. Now, you're not, again, on these facts, going to be getting into any real detail of quantum or a discussion of quantum, but you can recognise what the remedy would be. So on a successful application under section 422 subsection 1, the court may grant, order any of the remedies set out in section 422 subsection 3. These may include that the director contributes to the company's assets in liquidation. That's a couple of sentences worth of just distilling subsection 3 in slightly more practical terms than merely copying out what it says, which I'd like you to avoid doing if possible. Now, again, for me, logically, that would come towards the end of your advice. If you've established that there is the potential for someone to be liable, you then look to remedies. It's not the end of the world if, in fact, that came in your introductory discussion of, well, what is the purpose? What's the objective of pursuing an application before 422? Yeah, it could come in then. But personally, I would look through the potential liabilities and then come on to remedies, and that's where the remedies fall for misfeasance. So all 422 gives us is this very broad framework for discussing directors' duties, because you're kind of starting here with 422, and on these facts, probably C. That's the application by the liquidator. If it's successful, our remedy is under 422 subsection 3. But it's within this kind of void between the two that we need to think, well, how do we assess whether or not these directors are guilty of misfeasance or breach of fiduciary duty. That's the crux of the advice that Jeremy needs to receive. And it's there then that you're perhaps slotting in something along the lines of what I previously marked out on the board. We need to say that directors' duties are owed by the directors. Personal and right tells us that they're owed by the directors of the company, they're not owed to individual shareholders. Carlyle affirmed that. And set out a formulation of the director's duties in Guernsey law. SPL tells us we can look to the English jurisprudence if we need to, and that explains why you may then go on to look at these duties as set out in Carlyle, but further your interpretation, your discussion with reference to some of the English case law. Those are all kind of headline points. You've then got, and perhaps we'll do this after we've had a break, duty number 1, duty number 2, duty number 3. And as I said earlier on, I think, what does that mean? What does each of those in turn mean for our directors? And all of that builds you towards ultimately some kind of concluding paragraph to say, well, based on this discussion, it's arguable that Archie acted in breach of the duty to avoid conflicts of interest. As such, that would potentially justify the grant of relief by the court under 422 subsection 1 subsection C. That's a tie back then to that discussion. The remedy, 422 subsection 3. One other quick point that occurs to me before I stop for a quick coffee is everything within this dotted line is not fact specific. The only part of that discussion which goes to the facts is where you're looking to the application of the duties to A, B, and C. You have to have the facts in order to advance that discussion. Everything else in this dotted line is just a general discussion of the law that goes to directors' duties. And it doesn't matter what the facts are, that discussion is always going to look the same. And so certainly that was something I always looked for on my degrees, was what can I identify for the purposes of revision as having, as just being an area, a discussion which is just going to be consistent, which has no bearing on what the facts are, so that I can sit down and confidently know, well, do you know what, this is a question about directors' duties, and this is what I need to say. Now, my memory is such, and I've never shied away from saying, my memory is such that I would just perfect the discussion during my revision, I'd memorize it, and I would regurgitate it then on my exam paper, so that I knew, sitting down, here's the question on directors' duties, because you want every year, here's the question on directors' duties. I don't even need to think about these facts, because this is what I'm saying. You know, from the 2006 Act, obviously, this is what section 171 says, 170 says, this is what 171 says, da 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 da. Here it is. And then actually just knowing that there are certain points where I need to look into the facts and slot in my advice. And that was what I did. That's what worked for me. It won't work for everyone, but you've got a lot of law to learn and to be familiar with. Some of you dealing with it in practice, some of you not. And there are various areas where you'll see those core principles that make up a fairly significant discussion, on which you can pretty much learn now, because it doesn't matter what the facts are that you're presented with. That discussion of directors' duties isn't going to change.
Yep. Why is there not just a one-line question, please discuss directors' duties as they apply against you?
Because that's not the extent.
But then the additional 3 points of adding facts. Okay, let's do those 3 points.
But it's not.
Sorry, I'm just making that.
But it's not though, is it? Because it's not just those 3 points. On that little part of this answer, it's just those 3 points. But prior to that, you've got the rationale for why is the liquidator able to bring an action under 422. There are more factors to it than just that. Similarly, with remedies here, you're not going to give any real practical advice because you don't have the detail. But that's one building block. We've also got wrongful trading. You've got to work through
I guess
the.
why big line. I guess what it is seeing that and being able to offer the right issue. That's what it is. It's not just about knowing the law.
No,
Sure,
absolutely.
you need to know what to answer it, but actually the first thing you can test it on is to be able to find the right issue.
But there are ways and means of making life easier for yourself. And yeah, I totally take what you say, but you've always got to come back to the law. And in any discussion of directors' duties, those are the legal principles you've got to discuss. And it's necessarily going to be half a page worth of work to do so. But actually here, I don't think it's as easy, it's as simple on this one as simply saying, do you know what, those discussions of A, B, and C are a couple of sentences, because you've got a conflict of interest here, and that is not a quick discussion. Actually, that I would say is quite involved. Certainly within the Guernsey framework, because those principles, those provisions are quite well developed. And bear in mind what I said earlier, which is, from a marking scheme point of view, I'd be roughly saying you've got 15 marks here for setting out what the law is, and you've got 10, a significant chunk for your actual ability to advise. And so it goes beyond simply saying, I'm going beyond simply saying, well, this is the law, write it out. I'm just saying, to make life a little bit easier, there are areas where you can identify those discussions. This is one, and we'll look at an example of a question on minority protection later, but the same core points apply. Let's have I've run on longer than I was expecting, of course, as ever. So let's have a quick break, grab a coffee, and then just look at the, I think, the actual core duties in this question in isolation. Because they pick up on the meteor of the duties set out in Carlisle.